Thank you for joining this episode of 805 Talk, a show about what's happening inside the 805, with a focus on the Simi Valley and Conejo Valley communities. We bring you everything local business owners, nonprofit organizations, government officials, community leaders, and real estate. Here's our host, Jeff Landau.
Hello, this is Jeff Landau with Keller Williams, and thank you for joining me for another episode of 805 Talk, where I bring you inside the 805 and what makes up our communities. Today we have a conversation with attorneys Don Lanson and Janice Miller. We're going to talk about landlord and tenant issues, both for residential and commercial properties. Before we get to that, I want to have a really brief update for what's going on in the local real estate market. Without getting into too many numbers, though I think numbers will paint the story, just want to share with you what's happening in both Thousand Oaks and in Simi Valley. And if you have any other questions about other cities or larger area, just let me know. In Simi Valley, in April of 2019, we had 267 homes on the market, and last month we had 147. So that's a pretty big drop in the number of homes available for sale. And the number of sales also went down from 167 to 76. In Thousand Oaks, we had 187 homes on the market in April of 2019, and that went down to 120 last month. Pretty big drop there as well, and a drop in the number of sales as well from 58 homes in 2019 to 46 homes in 2020, so last month. We do have some things slowing down. I think everybody would expect that with the stay-at-home orders. There was a little bit of, I don't know if it's necessarily confusion between the federal government, the state government, and then the county, because there are multiple jurisdictions that oversaw what is an essential business. And for the first week or so of the stay-at-home orders, residential real estate was not an essential service. Then it got made an essential service at the federal level, not at the state level, then at the state level, not at the county level, and then finally at the county level a couple weeks in. So as real estate agents, we had a lot of confusion over what we can do, what we should do, what were the proper health codes and orders that we should follow. So I think it's kind of natural to expect a slowdown in April. At the end of March, we just were doing a lot just to maintain escrows for closing for the buyers and sellers that did indeed want to close escrow. And what happens in the future, that's certainly a crystal ball question. I think we need to take into account what consumer confidence is likely to look like, what income levels are likely to look like, and what's likely to happen to jobs. And we'll see how insulated our community is compared to the state and federal. So that will all unfold. Hope that was a good brief update for you. And now is a fantastic conversation with both Don Lanson and Janice Miller. And hope you get all of your questions answered, and they have their contact information at the end in case you'd like to speak to them. Hello, I am excited to have Don Lanson. Sorry, Don, was that too loud? Don Lanson and Janice Miller. It is May 6th. We are going to talk about landlord and tenant issues, both from the residential side and the commercial side. And both of my guests are attorneys. You may recognize Don's name from an earlier podcast last year. Don is with Manfredi, Levine, Eccles, Miller, and Lanson. And Janice is with Miller Haga. And we're going to get started. Janice is going to set the landscape for us on how we're going to be looking at what the laws are and the orders are. And there's no other way to do that than by starting at the top of what the governor's order is and then take it on down. So Janice, take it away.
Thanks, Jeff, and thanks for having us on the show today. Hi, everybody. I'm Janice Miller, managing partner, Miller Haga Law Group. We're business transactional lawyers, and a lot of what we do is landlord-tenant work, both from the commercial and the residential side. As Jeff said, Back on March 27th, Governor Newsom entered Executive Order N3720, which sets the stage for the state of California to give landlords and tenants, both from a commercial and residential perspective, some relief as it relates to the pandemic. So for a tenant to get some relief from his landlord, there are certain things that he or she has to do. First and foremost is they have to notify the landlord in writing that there's an issue and that the delay for payment of rent is as a result of COVID-19. And those tenants, those three things that they have to do is that the tenant was unavailable to work as a result of COVID-19, they experienced a layoff or loss of hours as a result of the pandemic, and they need to miss work as a result of childcare. Now, if that's the case, then through May 31st, unless otherwise extended, there are no evictions as a result of that. So that starts at the state level. And then we drill down to the different cities, and I'm going to talk about two. I'm going to talk about LA City, and then I'm going to talk about Thousand Oaks. So in the city of LA, there's both a prohibition on residential evictions and a prohibition on commercial evictions. And basically, they set the same tenants, and not tenants as in laws, but whatever. No owner shall evict a residential tenant for non-payment, again, as it relates to the pandemic. Now, here's a little switch. Here in the city, it says, the tenant may and owner may, prior to the expiration of the local emergency period or within 90 days of the first missed rent period, mutually agree on a plan for repayment of rent. And again, there is no fault eviction during the emergency. And more importantly, Jeff, and this is super important for commercial tenants, is the owner is not permitted to charge interest or a late fee on rent paid under the provisions of that article.
So commercial is 3 months.
Correct.
Okay.
Correct. Unless it's otherwise negotiated. And one thing that we're going to talk about a lot here, and that Don and I will both say, is tenants, talk to your landlords. Landlords, talk to your tenants. This is a time that we all have to pivot and work together. And if we come up with a really good solution, then it'll benefit all of us. Let me just talk for 2 seconds about Thousand Oaks, and then we'll turn it over to Commissioner Lanson. What was issued here basically says that residential and commercial moratorium on eviction, residential for both COVID-19, commercial for both COVID-19, again, until May 31st. And it prohibits the landlord from filing an unlawful detainer act. They also, in that order, stress communication between landlord and tenant. So what we're hearing at the state level, the city of LA level, and the Thousand Oaks level is no evictions until a period of time after the pandemic has ceased, or there's an extension of that period of time. And best course of action is to talk to your landlord. Don, what do you think?
So let's make this even more complicated. On top of state, county, and city rules, as Janice just went through, trying to figure out some way to create a balance of these interests and issues, and we'll get more into some of those issues. There's an additional governmental part of this process called the Judicial Council, which is essentially the organization that controls all of the courts. So the legislature and the governors and the mayors, and they can do their thing, and they have, and every, again, county and city has its own safer at home or stay at home orders. The court system got a little confused by all of this and came out with something that they thought would end up resolving the issue as to at least court access. And what this Judicial Council came out and said is, look, whatever rules are applicable that Janice went through, those are valid, those are enforceable. We're just going to tell you from a court system process, if it's a residential or commercial eviction, we are not going to accept a complaint. We are not going to process any eviction. We're not going to have a sheriff go out. We're going to do nothing as to any commercial or residential eviction process for 90 days after the governor lifts the state of emergency declaration, which could be today, tomorrow, 2 months, 3 months from now, who knows? So there's a good chance that 4 to 6 months, there's going to be a stay on all evictions from a court process on residential and commercial eviction proceedings.
So even if a eviction could be possible in the state, in the city or county locally here, the courts could still say, we're going to wait.
Correct. And
Okay.
With one very important exception that I have been asked about, oddly enough, and that is if it's a matter of public safety, not safety in terms of, a lot of landlords will say, hey, at the end of the day, he's ruining my property. That's a matter of safety from my family or the property. That's not going to be it. It's a matter of public safety. So for instance, and just to use an example that I actually have, is if a property is being run as a meth lab, that would be a public safety issue that we could then argue would be allowed in the process. Anything else, failure to pay rent, even by the way, if it's a no default, say for instance that the landlord wants to take the property off of being a rental, the courts are not going to process any eviction paperwork or have a sheriff go out or do anything, again, for 90 days after the state of emergency is lifted. So again, we're not looking at any evictions for probably 4 to 6 months at a minimum.
And so there's this guideline that Janice mentioned that has 3 different criteria, and it could be a job loss or somebody getting ill. What if there's a job loss and somebody has $70,000 in savings, and their rent is $4,000 a month or $5,000 a month, so they could clearly pay rent, but they say, well, I lost my job or I'm getting half the hours?
Good question, Jeff. The law at the state level says the tenant needs to delay all or some of the payment of rent because of an inability to pay the full amount due to reasons related to the 3 things that we talked about. It's going to be really difficult to prove what is and what isn't necessity, right? What is uncertainty? That's coming up now with the PPP and rules that the SBA has issued about what's uncertainty and not. If there's uncertainty on a go-forward basis, but there's still need on the part of the tenant that you just described, they may very want to hold on to that money. That's why you need to talk to your landlord and work something out. There's all sorts of other items that we can talk about, if you'd like, from a legal perspective, that tenants may want to look at. Number 1, is there a force majeure paragraph or some language in the lease? Now, generally, both from a retail and from a residential point of view, it'll say force majeure, acts of God, all these things, yada, 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 except you still have to pay rent. So tenants need to look at that. Landlords need to look at that. Then there's a compliance with the law provision in the leases. I'm a restaurant. I want to open up. I'm ready to open up. But wait a minute. There's an executive order that says I can't open up. So there's what's called frustration of purpose. I can't do it because I would not be in compliance with the law if I would open up. Therefore, I can't pay rent. There's an idea of business interruption insurance, and that's for a whole other podcast you can do on whether that's applicable or not. So these are the types of things the tenant need to look at. They need to speak with their landlords about. What we're going through right now, if you take a look at the Spanish flu from the 1918 time frame, that's the only history we have here. We don't have anything else to look towards. So while we have documents that say certain things and we have executive orders that say certain things, the best is communication with landlord and tenant and coming up with a new bargain for exchange.
So Jeff, let me kind of get back to one of your basic question is that from a documentation standpoint, what is necessary to establish that hardship? And the difficult thing is it's not specifically defined, which is one of the reasons the Judicial Council got so frustrated, because they didn't want to sit there and have a discretionary process as to exactly what documents would satisfy and what wouldn't. So on behalf of landlords, we get asked a lot of the time, hey, this person is still employed. They're doing better than they were before because they provide remote access services or whatever it is. And please write to them and say, we need their hardship documentation evidence. And I have a number of those matters right now where I'm writing to the tenant saying, hey, pursuant to you're still obligated for the rent. And by the way, all these rules and regulations does not exempt and waive any rent. The tenant is still obligated for the rent in ways that we'll get to. But the issue being ultimately is what evidence can be provided. Obviously, you want to see something that the person is laid off, furloughed, something like that. But beyond that, it may be difficult to figure out exactly what is necessary to show that hardship, again, which is why the Judicial Council said, you know what, we don't care. We're not even going to require that as part of this. We're just not going to process any eviction stuff at all. So you see a lot of landlords still wanting to push the issue. You'll see a lot of tenants very confused as to, wait a minute, I'm hearing that they can't do anything yet. This person's demanding that I provide them evidence as to what's going on. I think one thing that Janice said, it's really, really important. Yes, right now we're having a problem, but the key for landlord tenant is this is going to pass at some point. And if you don't work together and you upset everybody, I almost used a different word. If you upset everybody, all of a sudden you're going to have a lose-lose 6 months to a year from now when you want to renew, or you want tenant improvements, or you want some other concession.
And so what happens? Let's say we have somebody that doesn't pay rent. I'm going to focus on the residential side for a second. Somebody doesn't pay rent for 8 months, $3,000 a month, so they owe $24,000. Lease is over.
Mm-hmm.
They're not. They still have to make good on that $24,000 that they didn't pay.
Correct.
And then they hand the keys over and they say, "Okay, I'll see you later." Then the landlord has to sue them in court, right? I mean, what other means are there to have a tenant pay?
So again, initially, one of the rules is that the tenant has, on a residential lease, they have a certain period of time to make up the missed payments. And this is kind of back where Janice said there's going to be a lot of different jurisdictions that have different rules. Right. The tenant may have up to 1 year to make up those back payments.
Right.
Some jurisdictions, I think it's Thousand Oaks, it's 6 months after the stay of emergency is lifted that they have to make up those back payments. So there's some time period by which they're supposed to make those payments. If they don't, as you say, yes, it would be a court process at that point. But again, it wouldn't be necessarily to kick them out. It would be basically breach of contract and not making those payments.
Right. Don is 100% correct. It depends on the jurisdiction. LA City is a year to pay back the rent. And we're not saying in any way, shape, or form the rent is not due. It's not an abatement. It's not a deferral. I mean, it's a deferral. It's not an abatement. It's not a forgiveness. So it's over a period of time to pay back the rent. And the jurisdictions differ as to what that period of time is.
So one thing I'm seeing a lot, Jeff, by the way, is a lot of times, again, unfortunately, people are not doing well with the virus, or people are passing away and they're leaving the properties to their kids. All of a sudden they have to work out a deal with the tenant. And sometimes it makes sense to even pay the tenant cash for keys to get out, knowing that this could be 6 months or longer whereby this tenant is staying. So sometimes it makes sense to do that, especially if they want to sell it, because I know at that point you come in and you'll actually make the repairs at no upfront cost to the beneficiaries, and it gets paid out of the escrow at the end of the day, right?
Yes. Yeah. So in that case, so you're saying that you would have the it would be in the landlord's best interest to get cash for keys in that case, so they could start working on the property.
It could be from a business decision standpoint. It could be 6 months to a year before you get possession. It might make sense.
It also, with the court system going to be as backlogged as it's going to be once this thing is done, to me, Don is more of a litigator and I'm more of a business transactional gal. So I make love, he makes the war. So he wants to take everybody and he wants to go and he wants to evict them and go through the court process. I want to shortchange that, and I want to be able to work it out now so that you can rewrite a new lease, a settlement agreement or something, so that you, Jeff, can get in there and make the repairs and do what you need to do so that you have the keys to the house.
Okay.
And by the way, there are documents, agreements out there. There are form agreements, whether commercial or residential, that landlord and tenant can use to kind of establish a repayment plan, to at least have the discussion. Because that's the most important thing right now, that I get frustration on both sides of saying they're not talking to me because tenants, believe the landlords have it made. Because, hey, you're getting free money. Meanwhile, landlords are saying, hey, I don't have PPP. I don't get any governmental aid. I don't have any programs. By the way, my mortgage company is not letting me miss my mortgage payments because they have to maintain their Fannie Mae, Freddie Mac guarantee. And if I don't make a payment, they end up having a problem. So this whole thing is kind of an It's a Wonderful Life problem where it's all interconnected. And if they don't work together at some point, then it's going to end up being more of an adversarial process.
Exactly. Yeah. I mean, I have some rental properties. I spoke to one of my lenders because my property's vacant right now. I'm doing work on it, and at first they didn't know if they were going to offer a forbearance, and then they said it would be 3 months. And as just looking at it from a business standpoint, I would have done it if I could tack on those 3 payments at the end of the loan, but it would have been due in 3 months. So I didn't really see any kind of benefit in that.
I think that depends on each individual lender. I know some of the big guys, Wells, Bank of America, Chase, et cetera, are granting the forbearance, and some are tacking it onto the end, and some are saying exactly what you said, Jeff, is we want it 3 months after this is all over. So it really depends from a business perspective what your bank is willing to do or not.
But is it up to the bank, or is it up to the investor that provided, that bought the loan?
Well,
Right?
then you start getting into an issue as to who the servicer is and who the beneficiary is.
Exactly. Yeah.
And oftentimes the servicer has a certain guarantee obligation because they'll sell that to a beneficiary or an investor or whatever, but they have to take it back in the event there's a default or other things. So the servicer sometimes is extremely motivated to make sure the payments come in because they don't want to have to take the obligation back. So that it gets into, and by the way, most people don't even know if their loan is owned by Fannie Mae, Freddie Mac, or guaranteed, or who actually even owns the loan.
Exactly.
So it becomes even more of a problem.
Exactly. What happens if you have a tenant that can't make their payments right now, and let's just talk again residential, and their lease ends at the end of June? So the lease ends. So the landlord has no obligation on July 1st to let the tenant remain in the house.
That's not true. That's not true.
Okay. So there's a 12-month lease. It ends June 30th. The landlord can't have the tenant leave if the tenant claims hardship?
There's a wonderful new law that went into effect January 1st called rent control.
Right. Please take that further.
So there's a statewide rent control now where just because a lease ends by its own terms doesn't necessarily mean the landlord can kick the tenant out. If it's a year or more, that tenant has a right to stay there as long as the certain conditions are not met. And obviously one of them is the failure to pay rent. But as we're talking about right now, you can't push anything based on the failure to pay rent. So that tenant may have a right to stay there, even though they're not paying the rent because of the virus. They may have a right to continue to stay there under the new rent control law that went into effect again January 1st.
And may not be subject to an eviction for some time as a result of what's going on with the pandemic, putting landlord in a very, very tough spot.
So does a landlord now need to give 30 days notice if it's less than a 1-year lease, and 60 days notice if it's longer than, or if it's 1 year or longer? Or what does that new rent control law specify?
Okay, so a few different things that you mentioned. First of all, if the rent control only applies for leases that are a year or more. So if somebody or landlord has a lease that's less than a year, technically it may not apply to it. Also, the rent control doesn't apply to certain types of properties, single-family homes. It doesn't apply to other exceptions and exclusions. But again, assuming it does apply, one thing also, by the way, that you mentioned, a lease, if it expires on its own term, you don't have to give any type of 30, 60, 90-day notice. It literally just expires on its own terms.
Right. Okay.
And normally, I could do an eviction the next day because, again, it expires by its own terms without even a notice. But again, the problem being is that if it is a year or longer, then you fall in, and if it qualifies for this rent control process, you can't kick them out simply by virtue of the fact the lease is up or by virtue of the fact that they haven't made a payment if they're covered by this COVID-19 protection.
And you said that that's not subject to single-family homes or condos?
Generally speaking, it's not, again, unless it's owned by a corporation.
Right, corporation or LLC, I think, correct?
Yes.
Business entity. Yeah, a business entity.
Okay.
It's and again, obviously when they did the rent control, they had no idea that the virus was going to end up being a problem. It was basically to try to substantiate housing. And by the way, there were lots of other rules and things that were trying to be discussed by Scott Wiener up north to try to add more protections for tenants and housing. That obviously has gotten forgotten now by virtue of everything going on with the virus. But that was a big push to try to sit there and solidify some tenant rights.
So we represent a bunch of restaurants, and the restaurants are having major issues right now because obviously they can't be open except for takeout in certain jurisdictions. And what we're telling, I'm writing letters daily to landlords, and almost everyone is cooperating and they're doing a good job of it. But there are a few that have gotten pretty nasty, and they're sending default notices. So from a landlord perspective, I would say, great, send your default notice, set your groundwork, set your foundation. From a tenant perspective, what we're doing in these cases when we represent tenants is we're asking for rescission, because in the leases, both from a residential and commercial side, the fact that there's a default notice may mean that you lose some of your rights under the lease, Jeff. So for example, you might lose an option right. You might have material covenants, material adverse effect covenants. There might be lending rights for Freddie Mae, Fannie Mae, all that stuff. So check your lease, and if your landlord is going to put you in default to preserve their rights, double check and see if you can get a rescission of that default notice.
Hey, Janice, are you seeing a lot? I'm hearing one or two questions, but I'm curious if you're seeing a lot of landlords arguing that, hey, at the end of the day, your closure was not due to a virus or a pandemic. It was due to a governmental action, which is not covered under the terms of your lease, whereas a pandemic might be.
Interesting.
Not seeing that argument as much, and some of the force majeure provisions do have governmental action as one of the labels. So we're, the few that I'm dealing with, we're okay with, but that's a very good point, Don, for sure.
Well, there was a Musso and Frank. Lots of restaurants are suing their insurance companies over this weird distinction, because insurance companies are denying business interruption insurance coverage because of this little fun semantic discussion.
I have a two-part question.
Go for it.
So from a force majeure standpoint, the first part of the question is, do you find commercial leases, are they more AIR leases that are standardized, or are they written, per landlord and per tenant? And then part two is for either the AIR for commercial leases or the California Association of Realtor lease forms. Do those have a force majeure provision? And is that understood to be covered by the pandemic?
Okay, I'll take part of that question and then pop it over to Don. So the part that I'll cover is non-standard commercial leases generally do have force majeure provisions. Some of them even specifically call out pandemic or governmental actions, as we just discussed. Okay. But then they have this, 12 sentence run online that talks about all of the things that are included in force majeure. And then there's a line, and it's the lawyer's worst nightmare. It says, notwithstanding anything above, or notwithstanding anything preceding herein. And then they say, you're still required to pay rent, your triple nets, and all that other stuff like that. So are we seeing force majeure provisions? Absolutely. For the most part. Are we seeing forgiveness of rent? No, not at all. Don, what about the AIR form and the CAR form?
Well, unfortunately, on the CAR form, no, there is no force majeure clause at all. And in fact, I had a conversation with somebody today who, she's a doctor. She went into escrow to buy a house. The bank was teetering on pulling the loan because of various issues, but didn't. She ended up getting the virus and was sick for 40 days. Her family got sick. And finally she said, even though she waived contingencies, she said, there's no way they would actually push this issue if I cancel because of the virus and everything else. And the seller now is saying, no, there's nothing in there that allowed you for impossibility or force majeure or anything else like that. There's nothing in the CAR document for that. And I want to keep the entire deposit because you waive contingencies and there's no other, explanation that you can actually justify as to why you get your deposit back. And that's a very difficult issue because that is not in residential real estate contracts for the most part.
So that was for a purchase, right?
Correct.
And they probably did not have the coronavirus addendum before.
Correct.
that took. Okay, because that would be covered now if that form was used, which is an optional form.
Correct. And that's one of the difficult things about CR is the forms, as CR will point out, are all optional.
Right.
And obviously it can be changed and modified, but oftentimes you get into a transaction 2 months ago, you have no idea the severity of what's going to end up happening. And unfortunately, they didn't talk to somebody ahead of time to, like, for instance, I said to her, look, if the bank was going to pull your funding, probably a better idea to have not said anything and let the bank do that and then come back and say, I can't buy it. The bank won't even fund the loan. Right. At least you would have had some justification that was not your quote unquote fault. But by canceling on their own, they actually put the burden on them because they'd waived all contingencies to create that problem. Now, with that said, do I think a judge is ever going to want to see a case where a seller didn't allow the cancellation to go through and is keeping a deposit? Probably not. They don't like seeing that kind of unjust enrichment argument. especially given a pandemic. But it's one of those things where for a buyer to sit there and go through arbitration or even litigation for 2 years to sit there and get to a point of getting that decision, that'd be a lot of time and money to get there to that point.
Well, the interesting thing about that, Don, is probably since 2012, 2013, we've had a upward moving market, and we have no idea where not that we ever have an idea where the market's going. When you had, somebody still has the seller still has to prove damages after the buyer waives all of their contingencies and still wants to cancel.
Yeah, I think in this go ahead, Jeff.
Yeah.
I was just going to say, in this particular market, I think that the seller is going to say, wait a minute, it's pandemic. I'm not sure when I'm going to be able to relet that place or resell that place. She knew what she was getting into. She had the bank, she pushed to have the bank waive the contingency. They did. So I'm entitled to that deposit because I can't do anything with that now. On the other hand, to Don's point, which is a valid point, you're in a pandemic. By the way, she's a doctor. By the way, if she was working on the front line, I don't think you're going to get any judge or any jury to say whatever. You're going to say, give her the money back. So, as we've started the conversation, as I promised that we would come back to, it really all depends. And the best win-win for both sides right now is to sit down and come to terms. Everybody's going to win or everybody's going to lose in that particular instance.
Yeah, you also asked, Jeff, if there's a foreclosure moratorium of some sort. The state, Governor Newsom, got various big lenders to agree voluntarily to a moratorium. But unfortunately, private lenders are not subject to that agreement, there's no requirement that they stop. And I know a number of private lenders who are going forward with foreclosure proceedings simply because they want to make sure to get their money now while the real estate market is, somewhat decent in order to get their money back. So there's no necessarily a order that they can't foreclose, and I don't know if actually that would be legal anyway. But again, it's a voluntary basis.
Yeah. What about in California Association of Realtors leases? Is there a force majeure clause there?
Not that I normally see in terms of the of residential real estate.
Okay, the standardized form. Yeah. Okay.
Well, again, most of the time that clause has a lot to do with underlying business concepts. Usually, there's not going to be a government, some kind of impossibility of performance in terms of renting residential property. So it's not usually something that would necessarily come to mind. Now, by the way, you made a good point. A lot of landlords out there do their own forms because obviously they want to tailor it in a way that is best for them, and they want to take out some things that don't necessarily help the tenants. Happens a lot both in residential and commercial, by the way. Janice, I looks at 50 to 100-page leases all the time that have been so messed up in terms of provisions one way or the other. So it is there. The problem being is a lot of those times, people will put stuff in leases that may not necessarily even be enforceable. Like the one that I always look at is the waiver of the jury trial, which is not actually legal. You can't waive a jury trial, but everybody keeps it in there because it creates a psychological motivation to say, if you're going to end up losing an argument, you're not going to get a jury, so you might as well settle now. So that happens a lot.
Interesting.
One thing you did mention also before was there are some other forms. One of the CR has a notice to the tenant that they can pay their rent, which I love how they phrase that.
NTAP, that one, the notice of tenant. Okay,
yeah. You are able to pay your rent.
I was going to ask about I've read it. I've read it a couple times, and I'm thinking, do I need to send that to my tenant? Like, what's the point of that form?
Well, it's again, it creates the conversation.
Okay.
It opens the door. It opens the door.
Okay, right. So the form basically says, Mr. Mrs. Tenant, or if you're going to have any issues, let me know.
Right, and it sets. Go ahead, Don.
No, it identifies the fact of that you have not been relieved of the obligation, but then it invites, as Janice is going to say, invites that conversation to start in terms of exactly how we move forward from there.
Right. I was also going to say that it aligns with the requirements under the statutes or the orders. They're not statutes, but under the orders that you open a dialogue and that you give notice. Right. So having that dialogue is super, super important.
So it sounds like it would be a good idea for every landlord to send that to their tenant.
I think it would be a good idea for every landlord to send something to their tenant acknowledging that this is a difficult time, that we're living in a time of total craziness and uncertainty, and that, yeah, hey, by the way, it's okay, we're still accepting money for rent.
I have a number of landlords who want to just stick their head in the sand and say, look, at this point, I don't want to tell them anything that gives them the impression that they don't have to make the payment. And I get that. But in my opinion, based upon the world we live in, at some point, your tenant's going to talk to somebody or look at something or watch something that is going to go, hey, I don't actually have to pay the rent. So at some point, it's better to have that conversation sooner rather than later. And by the way, like I said, from both sides, and there's ways to actually then have a discussion. Janice and I have talked before in terms of, hey, if you want to have this discussion and landlords say, hey, I'll give you rent abatement X, Y, and Z, but I want you to, let's talk about at least extension, sign up for another year. That way, at least I have some security of knowing that I'll have, an increase in rent or whatever happens to be going forward. So there's ways to create win-win that it isn't necessarily going to be just stick your head in the sand and not talk to each other.
Right. That's really one of the top things that we're recommending for our restaurants that have been forced to close or other businesses that have been forced to close as a result of that. Now, I'm waiting on the feedback today from the governor, but the governor is starting to reopen things slowly. So bookstores, music stores, restaurants with more takeout, but still no sit-down service. You can't go in and buy clothing. You can get them dropped off to you. So from a retail perspective, from a commercial perspective, some of the stay-at-home stuff is going to be lifted, but it's going to be very, very slow. And what we're telling our tenants is, or what we're telling our landlords is, yes, we're going to be open, but that doesn't mean that sales or revenue are going to come back to any extent to the way they were post-closing.
That's a good point in terms of understanding kind of where the governor's orders and other orders come into play. And I get asked this a lot in terms of how to define what's an essential service under various stay-at-home orders. For everybody to understand, everybody in the state must comply with the state order. Any order issued by the governor applies to everybody in the state, no matter what. From there, there's county and city orders. Now, those county and city orders cannot be less strict than the state order. It has to be at least even to that. But some county and city rules can be more strict. And sometimes that creates a little bit of confusion. For instance, in Ventura County, we do not have a mask requirement. Their public health director did not require, as part of its stay-at-home order, that residents wear masks when out and about doing things, because that person did not feel there was any statistical difference between 6 feet difference with and without a mask. Now, if you go to LA County, you have to wear a mask, right, depending upon circumstances. So it's kind of like an HOA that you have to kind of look and say that they have to follow the state rules, but they can have more strict rules within a county or city, depending upon what the issue is. So it's very important for all of the people doing business, especially real estate agents and lots of people looking at homes, is to understand what rules apply in the area that you're in. And usually it's going to be county rules in terms of health requirements as to what type of businesses you can run. Can you have inspections? Can you have termite pest control? Can you have the realtor come in and do whatever they're supposed to do? I believe realtors are essential services in both LA and Ventura County, so that's not a problem. But some of the other services aren't necessarily all deemed essential.
And that's interesting, because when the presidential order went out at some point in the middle of March, real estate was not an essential service, and then probably 9 or 10 days in, federally real estate was, but for our state it wasn't. And then it was for the state, but then not in our county. And then our county made it like another week and a half later. So
it's hard to get everybody caught up. That's why the Judicial Council finally said, you know what, we're not going to wait for all you people to figure out exactly what is and isn't in terms of evictions. But it is a very big catch-up problem, and that was difficult to figure out. And by the way, it still exists, and Janice and I were talking about, is like, how long does the tenant have to pay back the rent they've missed? That depends on where you are. That's right. Literally a case-by-case, city-by-city determination.
So keeping track of this and where you are is uber critical when you're offering advice, or when tenants are looking at how long they have to pay back. When landlords say, no, you have to pay me back, it may not be the truth.
And it's such a sticky spot, because we don't want people to get. So, look, you could have a homeowner doesn't have the same right with their mortgage company as a tenant that has with the landlord that has the agreement with their mortgage lender. So it seems like tenants have more rights than the homeowner themselves. And it almost seems like sometimes the homeowner is pointed out to be the bad person. I was going to say bad guy, but to be.
There's an argument that a lot of what's happening right now may kind of go right to the edge of constitutionality in terms of issues. But again, keep in mind, the government's most important thing looking at is they don't want people to leave their houses. They want people to stay home. And that's what all these orders are kind of going for. And again, yes, it's obviously not fair to some landlords. Clearly it's not. But the primary goal of what they're trying to do is to force people to stay home because they don't want to end up having the virus get worse. Now, by the way, and not just get worse, but the key, what has always been a focus is not just controlling the pandemic, but also making sure we didn't overwhelm our hospital system. Because if we had everybody rushing the system like New York, all of a sudden we would have a very difficult problem. Whereas now I think there's 11 people in Ventura. By the way, for Ventura County, there's 600 total cases out of 850,000 people. I think there's 11 people in ICU. That's not good, but I'm saying that's doable. That's manageable in terms of the process.
Yeah, that's great.
Now, I think I read something, so I want to run it by both of you. Is a covered property exempt if there's no mortgage on it? Did I read something like? I think I read something like that, but it sounds like I may have misread it. That's why I wanted to ask.
Exempt from what?
I'm going to look at my notes.
Define covered property.
See, we're doing the lawyer thing.
Oh my God! Forget it then. I'm not doing that because one of you needs to be my attorney then. All right, I'll scratch that question.
Well, there's no exemption again from the moratorium on evictions that the Judicial Council is going to do. It's period. It doesn't matter what eviction it is. Again, commercial, residential.
Okay,
there is none. Period.
I read that. I read that wrong. I thought I read something that said if there's no mortgage on the property, then it doesn't apply, which is why I wanted to ask you both because it didn't sound right. Okay.
Yeah, and again, you said that it seems like renters have a lot more rights these days, and yeah, again, like I said, it's trying to keep them home. But on top of that, I think there's a big push developmentally, and again, I'm getting into my commissioner thing of trying to find more ways to allow housing and solidify housing because tenants felt that their situations were so volatile that they could be kicked out when their lease is up. Rent can be raised really sometimes without any limits. So there was a big push in terms of trying to provide some stability for tenants going forward, which is problematic because we don't have enough housing units. There's no new place to build anywhere around here. So it's really just a spot fill-in type process going forward.
Right. And then if you make it less advantageous for somebody to have a rental property, then they take it off the market. So
right. The other thing I'm getting concerned about, depending on Janice brought up in terms of, yes, you can open if they start doing that, is it may actually be more costly for some businesses to reopen than literally to stay closed.
I'm laughing
because of government benefits?
Because of unemployment versus PPP for employees. That's what I'm laughing. My next call is with some employment lawyer friends of ours, and we're working on what it's going to take to reopen premise and bringing employees back. And they may not want to come back because they can make more money on unemployment than they can working again. And then what as a employer do you have to do? And if you can't get people to open your premise, even though you're allowed to open your premise, then you don't have money to pay your landlord rent, and it's a vicious circle.
Oh God!
There's a rumor that some
3 more months.
There's a rumor that one state actually reopened its economy basically to shift the burden from unemployment coverage that the state had to provide to basically back to the businesses to actually pay their employees to then lower the amount of money they were paying for that. So it's a weird agenda-based process.
And it's definitely not, there's not going to be some like green flag that gets dropped and everything goes back to normal. So everything's going to get phased in, and it'll be by city and county and state. And
the government. Go ahead, Tom.
Good. No, I mean, the difficulty, as you're saying, is you can sit there and put parameters as to exactly what people are supposed to do and take away all of those limits. The question being is then, does everybody follow those? That ultimately is kind of one of the concerns, by the way, in terms of the trails that are both in LA and Ventura County, was why they closed them, is because people were not actually following the social distancing rules. And they thought, all right, fine. If you can't follow, it's the lowest common denominator problem. If somebody can't follow it, we're just going to close it for everybody. I think that ultimately got people a little bit upset about that.
And what I was going to mention to Don's point is that the governor has said what he wants to do is he's going to turn things on like a rheostat, not like a switch. So things will slowly come back in and dialed in, and he'll have the option to unswitch them and make them more dim if people aren't following the rules.
The one thing there will be a flag, if we have to identify that, is for the governor to lift the state of emergency declaration. Right. Because that will set in motion a lot of this landlord-tenant stuff in terms of obligations to pay and make up past rent and stuff like that.
So right now, that's the target date that we have to hear before is May 31st.
Yeah, or extended.
Or the 15th. Okay.
No, it's May 31st or 31st. Extended, and
okay.
I am sure that will get extended.
So the state rule is May 31st. The county rules are May 15th.
That's why I thought the 15th. Okay. So then the county. So which one takes precedence, or are they just completely different dates?
So again, they both apply. The state is always going to apply no matter what, but the county may have more. For instance, the county rules get into things that are a little bit more specific. Like if you want to have a large gathering, say a church service, you have to do it in your car. You have to have the cars placed 6 feet apart. There's various rules as to exactly how you do that, or weddings or funerals or other things that are in the county order that's not in the state order.
I'm going to pivot just a tiny bit. Have either of you heard of or have been following the proposed Assembly Bill 828?
I have not.
It is it would force a 25% reduction in rents. Okay. I guess we're not going to talk about that then.
Well, no, that's part of a lot of, like I said before, a lot of things that are trying to get passed to create stability for rental tenancies, which I can appreciate. I just don't know if it necessarily will backfire.
I think yes. Okay. I'm not going to say anything else because I would have said the same thing.
Yeah.
Well, and again, it's like, for instance, the rent control. I totally appreciate the need to provide some stability. The problem is like it creates that domino effect of saying if ultimately you're going to have that, fine. Then what does the landlord do in terms of maintaining the property? What does it do in terms of that relationship? So it just creates a little bit more of issues going forward, back and forth between landlord and tenant, which can work out. But in some situations that I've seen rent control, like in Santa Monica, it tends to be manipulated by both sides. It's not exactly a foolproof way of providing stability.
Well, and you could make the argument we're either a market-based economy or we're not a market-based economy.
True.
Wow. Okay. That comment went nowhere.
True.
Well, and by the way, the other thing to add into this in terms of some of the limitations on rental units is the state of California also issues new housing requirements for each city, which are coming out. I believe Thousand Oaks needs 2,700 new homes by 2029-ish, I think. The county of Ventura needs about 29,000-ish, I believe.
29,000?
So,
where's that going to come from?
For the entire county. For the entire county.
Where?
That's good question. Infill, that's where there's some development projects that will be infill projects here and there. But again, it's one of those things where we're trying to find more space. Some people are looking at this saying, yes, but now because of density issues, we don't want to have the virus. So there's going to be so many arguments back and forth as to exactly what makes the most sense in terms of trying to provide some stability for renters.
And you said Thousand Oaks is 2,700?
I think so.
And are those rental units that they'll be apartments or
housing units? So where people can live, whether it's rental or whether it's to buy, it'll just be units to live in. And that came down from the state. Yeah, the state. Right? Every was the regional housing numbers. It comes down every 7 years. And this is not meant to be snarky, although it certainly may sound it. Did they take a look at what land is available to see if that's even feasible? Or what building codes are? Like building codes could be 2 or 3 story, and the only way to go is up. Well, and you've hit one of and we're getting into a development issue, but one of the rules is and part of this whole process, like the initiative you had mentioned, is trying to get rid of a lot of those development limitations, height limitations, density limitations, to allow density, multi-use, allow different types of tenancies aside from what we're traditionally looking at as normal type of apartments. So people move here for one reason, and then we want to change it, and then people will not want to stay here, possibly.
Very good point.
or affect property values too.
Yes.
Right.
You're hitting
Well, that's
the nail
one of the
on
big
the
issues.
head.
One of the big issues going forward, obviously, is what's going to happen following when we come out of this. If we're in a recession, whatever, what happens to the property values? I actually was curious. What do you think is going to happen to the property values going forward?
What do I? So, are you asking me if my crystal ball came yet?
Yes.
So, the way it seems that if we're very likely to have less jobs than prior to the virus, we're very likely to have some people making less money. So if we're going to be making less money and have less jobs, it's hard to imagine a stronger real estate market for me. Now, does that mean that it's going to happen right away? I mean, like right now, as of today, prices have been firm in our area. But I took a look at the numbers just in case one of you asked me a question like that, just to see, where we.
Nice lob ball done.
Well, no, just making sure. Look at all my notes here.
Love it.
It's we have a lower amount of inventory, which has been like this rally cry since 2013. So we in certain circumstances we have 30% less homes or something like that. I mean, I'm not going to go into exact numbers, but we have less homes on the market right now. We still have some buyers out there. So the buyers out there right now are looking for certain property, and they are ready to buy. What is this going to look like when things start opening up and we start seeing, are there job losses? If there are job losses, what do those job losses look like? Does the unemployment rate go, I saw some numbers a couple of weeks ago of expectations nationwide for the unemployment rate to go to about 9% from 3%, which I thought 9 would be amazing. Because I was thinking it would be a lot higher. Now we're seeing higher numbers. So, how
well,
is
and keep in mind
that
that 9% just means that's the number of people applying for unemployment. It doesn't necessarily mean the number of people that are unemployed.
So that'll be probably even be higher then.
Some industry indicators from last week, Jeff, to your point, don't show like a full recovery until fourth quarter 2021. Which who knows, but they're modeling it based on where we were and where we are. I think from a housing market, are you looking at something similar?
Yeah, I mean, I would have a hard time looking at data that would suggest the market to be as stable next month and 2 months and 3 months than it was on March 1st. I mean, we had a very robust, a very strong market. We had multiple offers everywhere. We had a lower amount of homes available for sale. We had buyers out there. We had great interest rates that got even better. So we had a very strong market, and it would seem, I can't see a reason why the market would be even stronger than that as we start easing into what our new normal is.
And by that, it brings up a good point, landlord tenant wise, is for landlord tenants going into an agreement, take into consideration, obviously, what's going to happen in the market as to how long you want your term to be, or how many options to extend, or how long those things go into play, because you may want a shorter or longer time period, depending on who you are, to adjust to whatever the market may end up being.
And oh, by the way, what about that second wave? And if we get a second wave in the fall as being predicted, where does the government step in again? And does the government again halt evictions and moratoria? And if we're just getting into that, if we were, just about ready to be able to evict people for phase 1, what happens if this happens again? So let's come full circle and say, for me, from both a landlord and tenant perspective, I think the win-win is to have an open dialogue and communication, to understand what the pros and cons are. Everybody sort of has a boss. A tenant has the landlord has the bank probably has some other lender or something like that out there. And everybody just really needs to cooperate at this point in time.
Awesome, Janice. Really, thank you for sharing that. I mean, I think that's really a great way to to finish our call here, is because, and I think Don brought it up. You're right. At some point, this will be over. Though, I would think it's hard to imagine not having a second wave coming, towards the fall and or winter. And if we have some animosities built up now, it's certainly not going to be better should we, come into a similar situation in 6 months.
Agreed.
Yeah. Any last minute thoughts before we put a bow on it?
I would just say the governor's Thursday is going to come out with a revised order, as Janice indicated, which probably is going to follow various counties coming out with also new orders or amending their orders. Very important to read those to understand what restrictions have been lifted, minimized, changed, especially if you're going to end up going on trails, go shopping, whatever it happens to be. So read those carefully and make sure you understand them.
And stay on top of what's going on, because over this past weekend, the SBA issued not one, not two, but 3 revisions to their FAQs. So if there's questions, if there are questions out there, just stay on top of everything that's going on out there, because the news that you might have heard today might be changed tomorrow or the next day.
To that point, we've had we've had updates to certain forms. The California Association of Realtors created the coronavirus addendum.
Mm-hmm.
There's a property entry advisory disclosure, and these forms have changed a couple of times since they've been out. So it's a very, very fluid situation. Can both of you please give us your contact information in case any of the listeners would like to contact you?
Sure, be happy to. I'm Janice Miller. Our firm is Miller Haga Law Group. We are in Calabasas, California. My email is very simple. It's jmiller@millerhaga.com. We're on the web. And my phone number is area code 818-591-4200. Let me end by saying, Jeff, this has been an extreme pleasure. Thank you for having Don and I. We have a good time tag teaming and going around talking about real estate landlord tenant issues, and it's a pleasure to have been here for your guests. Thanks, Jeff.
I also want to thank Jeff for at the fantastic Keller Williams for having both of us. Don Lanson, Manfredi, Levine, 805-379-1919 is the work phone number. Westlake Village is our office. Glad to help out any way we can.
Awesome. Thank you both so much.
Thank you for listening to my daddy's podcast.